In Focus continues tonight. Jailbreak accused Thabo Bester, disgraced Dr. Nandipha Magudumana and 7 co-accused are set to return to the Bloemfontein High Court on Wednesday. During his last appearance, the man, dubbed the Facebook rapist, claimed unfair treatment and has even asked the court to sentence him to death. The Bester and co-accused pre-trial conference was postponed in June. Legal expert Zola Majavu joins us now for more on that. So Majavu, good to have you, and thank you very much for your time. There's a lot that, of course, is being said around what possibly could happen tomorrow. The last time legal representatives, some were awaiting financial instructions, some withdrew. There were complaints about the treatment of one of the accused in terms of rights to consultation. All these things saw a postponement. Do you see that these matters have now been resolved, or we are likely going to see a similar kind of situation playing out?
Firstly, good evening, and good evening to your viewers, and thank you for the opportunity to shed some light with your viewers. It's a bit hard to say, however, given the multiplicity of the accused persons as well as the multiplicity of defense counsel, I think that it is unlikely that all of those issues would have been resolved. Resolved in a sense that all of them would be in a state of readiness to proceed to dispose of pre-trial issues. I don't see that happening. For example, as far as Mr. Bester is concerned, he is likely to be assisted by a new legal representative, who himself would need to be formally appraised of the developments, the contents of the docket, to enable him to confirm before a judge that, one, he has received the financial instructions, which is money, or there is some arrangement in place, and two, that he would have gone through the docket to enable him to say to the judge whether or not he intends making representations or making applications for further and better particulars, or dealing with any other interlocutory applications as instructions might have been. So I do not think we are going to see the matter being resolved tomorrow. What may possibly happen is that, as far as legal representation is concerned, that may tick the box to say all the accused persons do have legal representatives, and those legal representatives may be at different levels of state of readiness. And it is unlikely that we will see tomorrow being converted to a pre-trial hearing. What is likely to happen, in my own view, is that tomorrow may see the court setting another final date for all pre-trial hearing matters. Because before the court can certify this case as being trial ready, the court must be satisfied that all disciplinary issues that would sometimes negatively impact on the smooth proceedings of a trial are resolved. There's no point in allocating this matter, for example, 6 consecutive weeks, if midway one of the lawyers is going to withdraw because they haven't been paid, or if one of the accused persons decides he's going to fire their lawyer. The unfortunate part of it is that if one such a person decides to terminate the mandate of their lawyer, it has a knock-on effect on everyone else. There may well be issues of interpreters. There's also a serious logistical issue with regard to Mr. Bester himself, because he's Captain Kosi Mampuru, which is in Pretoria. If this trial were to continue in the Bloemfontein High Court, I do not see how he'll shuttle between Pretoria and Bloemfontein daily and to arrive at court on time. The cost is going to be huge. The logistics and the security arrangements are just going to be a nightmare. But I guess we'll just have to wait and see.
So are these things, I mean, with the gap of close to a month now in between, are these things that only can be articulated once that court is sitting? So if, for example, yes, now we have legal representatives, not something that you can just inform the court prior to the day of the matter sitting?
Ordinarily, I've been involved in matters where, amongst ourselves as different counsel acting for different accused persons, you communicate amongst yourself, and by the time you all rock up at court, no one is surprised because you would have told each other. You even create a simple WhatsApp group so that there's no element of surprise. It is unfair to expect the court to hear for the first time about these issues that you could have collegially sorted themselves out between yourselves, including the senior state advocate charged with this matter. So you are right. these things ought to be resolved way before everybody comes to court, so that when you come to court, you're going to congregate in a judge's chambers and say, Judge, amongst ourselves, subject to approval, we have agreed that these are the dates that will be suitable for all of us for purposes of a pre-hearing, or we've dealt with all of these issues, Judge. We are all prepared to go to trial. As far as accused number 1 is concerned, I am intending to call 2 witnesses, number 2, number 3, number 4. The state may also say to the judge, Judge, I am intending to call no more than 6 witnesses. Then the judge, informed by all of those factors, may then say, okay, let us allocate for a start 6 weeks or 3 weeks or 4 weeks as a start. You assist the court by talking efficiently and effectively amongst yourself. If that doesn't happen, it's going to be very frustrating for a judge, because this one person is going to stand up and say, this day doesn't suit me, or I haven't been paid. This one says this. Strictly speaking, judges must be insulated from that type of arrangements, because the judge doesn't even know what's going on. All the judge knows is that I have this matter that I must certify to be trial ready. These are the generalized nature of the charges. Other than that, the judges pretty much come to it very cold. So you are right in saying they should be easily resolvable amongst all parties concerned, because they are the ones who are sitting with the docket. The judge doesn't have the docket, doesn't even know what is contained in the docket.
Right.
So strictly speaking, as we speak now, all those lawyers involved in that matter should be knowing fully well what it is that they're going to tell the judge when they converge in chambers in the morning. Unfortunately, you and I are not privy to that, and we'll only find out for the first time tomorrow. In fairness to my colleagues, maybe they have done exactly what I'm suggesting can and should have been done.
Now, you mentioned some interlocutory items that could possibly bring some delays here. One of the issues is this question of confidentiality in consultation, right? The judge advised Mr. Bester last time to say, well, look, you can't just bring this thing up like this. Bring forward a proper application to this court if you want to raise that matter. I also made some suggestion about a death penalty petition. I don't know how the courts would want to handle something like that. But let's talk firstly about this confidentiality in consultation. Could that be a matter that would then need to be discussed before, once again, you go to pre-trial? And that could be a trial within a trial in itself.
Look, remember, the person who alleges some form of irregularity or violation of their rights must formulate that and concretize that in a formal application. And the judge was correct. You don't just walk up and say, kill me now or do this or that, because certain things that should have happened have not happened. So you have to bring it in a form of a substantive application where you give formal notice to all those that are concerned, or all of those against whom you are making these allegations. Secondly, the issue with regard to confidentiality is not something that a judge can just simply deal with on the spur of the moment. He knows what it is that he alleges violates his rights. And obviously, if he had consulted on time with his client, he would have prepared that application by now. That application would have been served on the state and all other parties concerned, and all that should happen tomorrow. If there is really seriousness about that, that application should then be ventilated in open court. But if that application has not been prepared, I think any judge will be justifiably livid about that, because you've wasted another 2 months about instructions that you would have obtained from your client. It would not be open to Mr. Bester to come back now and say, look, Judge, I only saw my client, my lawyer yesterday. I need another postponement. Yeah. Because that is unfair on those others whose affairs with their lawyers are in order. So by interlocutory applications, I simply mean any application that happens in the intervening period before you get to the business of the day. If you know your client has complained about unfair treatment, as a lawyer, you know what you must do. You should have done that application, served it on everybody concerned, and all a judge has to do is to formally adjudicate over that application. But nobody is going to be granted any further room to maneuver by a judge. And I'm not prejudging what might happen, but this matter has gone on for far too long. Everybody has a right to legal representation, but the judge is not just a neutral umpire. The judge is in charge of the proceedings to make sure that judicial time and resources are spent correctly, that the rule of law applies, and justice is not seen to be delayed. It's as simple as that. So I think chances are the judge is probably going to adopt the hardline approach to say, gentlemen or ladies, get to act together. Are you ready? Are you not ready? If you're not ready, explain to me what is outstanding. Why is it outstanding? State, are you ready? If the state says, yes, we are ready, then he's going to say, have you shared the information that ought to have been shared with your opposite number, which is the defense counsel? If the answer is in the negative, a judge is going to say, why has that not been done? Why are you only making this information available now? Because the knock-on effect is that the defense is going to jump up and say, we only received this information now. We had no way of dealing with it prior because it was only brought belatedly. So I think everybody's going to be on a tight leash tomorrow.
Yeah.
It's my very informed guess, yeah.
And finally, let's talk about this question. One of the accused whom charges were withdrawn, however the state saying provisionally, is now expected to turn state witness. And there's this whole issue about whether or not this is done properly. I think she was served with a 204 for protection against prosecution. Is that necessary, having had charges withdrawn from her previously because of lack of sufficient evidence?
Let me put it to you this way. It is always open to the state in the form of the prosecuting authority to decide who to proceed against, who to withdraw charges against for different reasons. They may tactically withdraw against one person whom they believe they can use as a bait to get the bigger fish. So they say, instead of proceeding against you, we know that you yourself are an accused person. We know that we believe that we have a solid case against you. But in the bigger scheme of things, we don't really want you. We want someone of a greater interest to us as a state. So as a quid pro quo, in return for you testifying against your fellow co-accused, we will not proceed against you and withdraw charges against you provisionally. However, a Section 204 indemnity presupposes a situation where you still testify in a court of law as an accused person, and it is open to the court to then make a determination whether you testified truthfully and honestly to the best of your ability. If the court is satisfied that your testimony was truthful, then you may be granted indemnity from prosecution. It is quite risky because the state may promise you indemnity, but the court may not be satisfied with your testimony at the end of it all that you testified truthfully. So in some instances, if I were acting on behalf of such an accused person who the state wants to use, I would say withdraw charges against my client completely. I don't want to hear anything about this 204, because then once charges are withdrawn against that particular person, he may not be charged again based on the deal that you conclude with the state. So it's a double-edged sword, so to speak. So if you want to indemnify a person on the back of a 204, the final decision is not that of the prosecutor. It is that of the court upon it being satisfied that you have testified honestly and truthfully. But it is really of no moment.
Yeah.
The state already knows who out of these accused persons they really genuinely believe that they have a case against. It is not uncommon for the state sometimes to adopt a scope, skip, and donor approach and just charge 10 people when they know that in honest and in truth, they have a strong case against the 5. So they just use the others to shake the tree and hope that something may fall. And those are their tactics, nothing wrong with that, but it is also not the kind of lawyering that is encouraged. The prosecutors must prosecute without fear or favor, and the prosecution is also enjoined by law where it has reason to believe that it does not have a good case against a person based on the evidence at its disposal, or it has evidence that may prove to show or tend to show that this particular person is in fact not guilty. They are obliged to share that information with the defense, even if it leads to the charges against that particular person being withdrawn. So there's a lot at play, and this is what I suspect may have happened. Not everybody out of those 9 or so accused persons, I believe that the state has a strong, solid case against them. It may well be that they may withdraw against other further persons tomorrow, provided that they will use the evidence of their co-accused to try and use them against each other. Because remember, even if one accused person were to confess, his particular confession may not be attributable against other non-confessing accused persons.
Yes.
So it's not as if the state is plain sailing. The state is having difficulty itself. They may show both and say, yeah, we really want to go through. But the test is going to be on the evidence they have against each and every single one of the accused persons. And we are still a bit far away from that particular moment. We have to get past the pre-trial stage. The judge must, upon being satisfied that all is honky-dory, then certify that case as trial ready. Only then will the person who is in charge of the central register then allocate 2 weeks, 4 weeks, 10 weeks, or whatever the case might be. But none of that will happen until the financial instructions, which is a euphemism for lawyers saying I haven't been paid. We call it financial instructions. I don't know why you can't just say this man hasn't paid me. But be that as it may, when reference is made to financial instructions, which you will hear often, you must simply know as viewers that a lawyer is saying I have not been paid. The lawyer has not been paid. There's no judge who's going to certify that matter as trial ready. The judge may likely say, clearly you, Mr. X, cannot afford your lawyer, apply for legal aid and do it now, so that on the next occasion, we don't have an issue about lawyers. There's no point you wanting a Zola Majavu or a Mr. So-and-so if you can afford it. It's as simple as that. You have a right to legal representation of your choice, but you must be able to afford them. If you can't, the state will provide you legal representation, not of your choice, but that which the state will make available for you. So all of these nuances are a balancing act that I think a judge is carefully going to do. And there before a senior judge, a very seasoned, experienced judge, and I do believe that he's probably going to put his foot down and say, chaps, enough and no more, without violating anyone's rights. But the case must get going because there are judicial resources. The judges are not sitting there waiting for this case. These judges have got other pressing cases that are on their desks. So their time has to be properly spent. And that is why you will find that the courts are generally reluctant to enroll matters for trial, unless all of these issues that we quibble about have been resolved. Let me quickly touch on the issue of Mr. Bester's petition about him being sentenced to death. That is atmosphere. It's not going to happen in our constitutional dispensation. The death penalty was abolished, and it is not going to happen, not because Bester asked for it or anyone shouts from the rooftops. It simply does not exist in terms of our legal dispensation. And I'm not suggesting that Mr. Bester has not been unfairly treated. There may well be a case that those who are responsible for his care have to answer. The fact that he's a convicted prisoner does not mean that he has to be treated less of a human being, because the Constitution, which encapsulates the Bill of Rights, is of equal application to him, no matter how much you may despise him. As far as these charges are concerned, the law says he is innocent until proven guilty, and he has to enjoy the benefits of every single accused person. And that is why on the previous occasion, I think the judge granted him the latitude, because the judge sees an innocent person. The judge does not see this person that we despise because of his past, even if he is a condemned and convicted prisoner. That's not how the judicial cookie crumbles, unfortunately.
So Majavu, appreciate your time. Thanks so much for coming on this evening. There, Zola Majavu giving us some analysis.